Welcome to the Private Practice Survival Guide podcast with your host, Brandon Seigel. I'm a published author, speaker, entrepreneur, and private practice strategist dedicated to transforming the way that healthcare functions. This podcast is all about empowering you to create the change you want to see. Let's dive in. Welcome back to the Private Practice Survival Guide podcast. I'm your host, Brandon Seigel, and today I am joined by someone really special who's truly changed my business and supports me on a regular basis, none other than my own business attorney, but also the attorney of many of the practices we work with. Welcome to the podcast, Vanessa. How are you?
I am good, and thanks so much for having me. I'm excited to have this conversation.
Yeah. So, Vanessa, why don't you talk a little bit about just like your background as an attorney, what you do with businesses, your firm, and just give them a quick overview for our audience so they know who we're talking with today.
Yeah, awesome. So my name is obviously Vanessa Ferguson, and I am the owner and founder of Fedara Legal. At Fedara Legal, we help people start, manage, and protect their business by building long-term attorney-client relationships through our flat fee services and our counsel membership, so our subscription services as well. And we have a very interesting niche. We are a business law firm that focuses on intellectual property and privacy law as well. So I always tell people who encounter me, we're not like, your average lawyer. We're a cool law firm. So that's what I like to tell people.
Well, and before we jump into this episode, something that I want people to know is like, obviously, those who know me, I've been in business in different aspects. I started my company before I met Vanessa. Vanessa came highly referred to me, and a lot of what we had to do was tighten up pieces of my legal, quote unquote, foundation and fundamentals that I just didn't know better. And so from intellectual property to business agreements to buy-sell agreements and different things we're going to talk about throughout our different episodes together. But I just want everyone to know that like a lot of the time, we don't know when to engage a lawyer and when not to. And my rule of thumb is when you have the right attorney, part of that is they want the best for you. They're going to tell you, hey, this is when I think this makes sense. This is when you can kind of pave your way. But I do find right now, one of the big things I'm running into is a lot of practice owners are trying to do everything themselves through AI. And it's a little bit scary. And so I literally referred you someone the other day, and I talked to him today, and he's like, well, and I'll go, no, you're not going to LegalZoom. Let's talk this through. You have a misunderstanding. And so I bring this to each and every one of you practice owners, like there is so much more risk and negligence than knowledge. And so protect yourself, have the right partner, have the right ingredients that is supporting your knowledge. And then from knowledge, we make the decision of the execution of when legal support and legal advice and legal documents are needed, et cetera. So today, Vanessa and I are going to be talking about this thing that I call legal landmines. And so when we think of landmines, we think about something that we step on that we didn't know was there and it gets us in trouble. And so we're going to talk about how do we protect our practice before problems arise. And so, Vanessa, I'm sure you see a lot of mistakes with small business owners, private practice owners, et cetera. What are some of the common expensive mistakes that you're seeing with small business owners right now and seeing with potentially private practice owners as well?
Yeah, I think the easiest one is always contracts. I think people really don't understand what a contract is. They don't understand how easy it is to enter into a contract. They don't understand that contracts are binding, that once you sign it, outside of fraud and maybe one or two other excuses, you can't get out of it. And really, I think an expensive landmine is when people come to me after the contract has already been signed and they're trying to get out of it. I had a conversation with someone who was interpreting their contract, and they were like, so if they're breached it, does that mean that it's null and void? Or I was telling them about terminating it. If they terminate it, does that mean that the contract is null and void? And I had to explain to them some terms in a contract survive the termination of a contract. Non-competes, non-solicitations, confidentiality agreements. These clauses survive the termination of a contract. And just I could talk about contracts for the rest of my life and still be in my grave still talking about contracts. There's so many nuances of them, but I think the most expensive one is just not understanding that contracts are binding and really understanding that there's a lot of value in reviewing contracts prior to signing them.
And I want to be clear, there's two different aspects of this. One is the contracts that we sign, which is, I think, one of the things that Vanessa's finding as a landmine is you sign a contract that you haven't had someone legalese review. And what you need to understand in this circumstance is anytime someone else facilitates a contract, it's written to their own benefit, not yours. So a lot of us will invest in the other side, which is, hey, Vanessa, I need an employment agreement. I needed this, I needed that. And that often is, written in our best interest. So it's not as, it's still a very important deal. But I think the landmine that Vanessa is specifically zeroing in on is the contracts you sign. And so whether that's a contract for equipment, that's a contract for staffing, that's a contract with a funding source, all these different aspects. And so I find from a medical billing provider standpoint, every time I ask a provider, do you understand and know what is in your contract? The answer is no. And what happens is we go into a contract and we expect it to be fair. And correct me if I'm wrong, Vanessa, but a lot of big corporations take advantage of our naivety in the clauses that they hide in an agreement. Would you agree with that?
Yeah, I wholeheartedly agree. This is kind of what drives me personally and a lot of the values at Fedar Legal. So when it comes to, not everything is worth redlining, not everything is worth negotiating. You have your hills that you die on per se when it comes to contract negotiations. And if it's not something that it's an absolute deal breaker, then you just, you figure it out as you go. But there are some things that are deal breakers. But a lot of people, for when they go into these negotiations or they look at a contract or they don't even look at it and they don't know kind of what it is that they're looking for, what they do have right to negotiate. Sometimes they even over negotiate and the deal gets ruined. But I think to your point, I definitely agree. I think a lot of, I call them corporate conglomerates, which might not always be the best word, but a lot of these people they prey on small business owners. They prey on them because they know that they don't know a lot about entrepreneurship, or they don't know a lot about contracts, and they get them. I always tell my clients the biggest red flag is that you will get in a room, and Brandon, I'm sure you've been there, I've been there before, and they'll make it seem as if you don't sign this contract today, the deal is off the table. And when there's a lot of dollar signs and a lot of zeros behind these numbers, you panic, especially when you don't have an attorney in your back pocket like you do, Brandon, who's like, hey, Vanessa, this is what's going on. Is this a good opportunity or no? You panic and you sign the contract without even looking at it, without even, the only thing you look at are the other dollar signs. So that's one thing that I see. And then when it comes to being presented with a contract drafting versus contract review, I always tell my clients that it's more affordable to review a contract than it is to draft a contract. And then it's more expensive to draft a contract than it is to review a contract. But the person, as you mentioned, the person who's drafting the contract is the one who has the most leverage, because when drafting a contract, you are future thinking. You're thinking about what could happen next year. And, honestly, sometimes within the next 10 years. So a quality attorney is drafting, thinking about not where their client is now, but where they will be in the foreseeable future. And they're drafting the contract in a way that will protect not where the business is now, but where the business will be. And someone who's reviewing an agreement, you don't have that intel that the person drafting it had. So you could never address those concerns. So yeah, you're exactly spot on that. Contracts there's just so much power in them, and it's not to overwhelm people. You don't need to read every single contract that you get. And from an attorney, that probably sounds crazy for me to say that. But what I teach is how to navigate a contract so that if you do have a question, is, this in the contract, how to figure out where it would be if it was in that contract. And then on a similar but different note, it's also important to keep in mind that I just lost the train of thought. It'll come back to me. But yeah, these are very important questions.
Well, and I'm going to piggyback on this for you to also recognize something. it's going to be less expensive. And from a time is money, from a time standpoint of everyone, to review something and be proactive than to fight something reactive. The
Exactly.
amount of practices that I see sign things without further review baffle me. And I would say very transparently, at least 75% of the terrible contracts that I have seen in this consulting role that I play have never been fully duplicated by the actual business owner.
Mm.
So what happens is they desire to have trust in the party that they're contracting with. But the reality is that contract is built on the precedent of how are they protecting themselves. When I create an agreement, at the core, my agreements I send to you are to protect me. Now, I make it in what I call plain English because I'm not trying to dupe anyone. But at the end of the day, the biggest thing when I met with Vanessa and said, let's go over my agreements. Let's go over the agreements that I send on behalf of my company to clients, etc. The number one thing that I asked Vanessa to make sure was loud and clear was that I am held not liable, that everything you do is elective, and that I hold no weight on the repercussions of that relationship. And some of you sign that agreement and then you come back to me like, blah, blah, blah. I go, look at, like, oh, I missed that. And it's not that I'm trying, but these are the reasons why, I do these, Vanessa, as you know, I have a conference that I put on and I have these sponsorship agreements. I have only had one company ever come back to me and ask for changes in the sponsorship agreement. And it's just interesting to see how few businesses actually evaluate contracts and they just sign it. And I recently had a new client that came on board and he signed a contract. I actually, before he signed the contract, I said, I want to make sure you understand the pay scale, like the pay schedule that you're paying. And he's like, yeah, yeah, yeah. And he signed it. And then I sent him the invoice. What does he say? He's like, well, what's this? And, and I go, didn't you see the pay schedule? He's like, well, I don't know if I can do that. I'm like, why'd you sign the agreement? Like, so my number one thing is that we need to understand that every contract you sign has a binding agreement that you're either going to settle or you're going to spend a lot of lawyer fees. Because I guess my question to you, Vanessa, is in small business, what is the percentage of lawsuits based on contractual disputes actually reach judgment versus settlement?
Yeah, this is a very common question that I get, and I repeat this stat all the time. It's been a while since I heard the stat, so I recently went back to confirm that the numbers are still correct, and they are. I think they might even be higher, maybe 98%. But what I tell people and what is about the average is 97% of cases settle before going to trial. So we do a lot of demand. I always send out a demand letter first. Let's try it. Let's try to get it resolved. And if they're not willing to resolve, then by all means, we have no choice but to move forward with the lawsuit. But even when the lawsuit is filed, I tell them it's going to end in a settlement. What those numbers look like and what the settlement is going to look like varies, but it's going to end in a settlement because it like why you never know how things are going to end when you take things to trial. So, and even cases that even make it get assigned a trial date, they usually still end up settling right before, like the day before, the evening before trial. And it's like, why do we play this game? Like, just, yeah. Yeah. So 97%.
And, and then the other question I would kind of pivot on this from a landmine standpoint is we also have to see that there are times where certain states or certain courts of law favor one party over another. So those agreements won't hold up the same way that other agreements. So whether it's a non-compete or a non-solicitation or a termination agreement or whatnot, I always say in California, the employer will never be favored over the employee. So regardless of what your employer agreement is, the employee's freedom will take weight over that. And so it ends up being scare tactic. And so from your standpoint, what does that look like from a strategic standpoint in terms of protecting a business entity? Do we worry about the way that court of law, or do we always go for the most protection in terms of our legal approach, whether it be with employees or clients or whatnot?
Yeah, so I think what I hear you saying in my legal ears are governing law and jurisdiction clauses. Not specifically in the employment space, because some states will always have control depending on, especially if the employee lives there, depending on the situation. But the unrelated topic that brought this to mind was a lot of people, especially in the tech startup space, they want to register their businesses at a Delaware C Corp. And I always tell people, by all means, if you tell me a law that benefits your business in Delaware, and then I'm happy to have the conversation with you. But a lot of people, I call it Instagram and TikTok CEO. They see you start a business, you get a loan out for $2 million, now you're a billionaire. And I always tell them, if you can give me some type of benefit in Delaware that benefits you, by all means, let's do it. And I think for a lot of specific businesses, it does make sense. But one fact that I found when I was helping a client with another dispute is that in Florida, you can't have more than 18% interest. Outside of like credit cards and some exceptions, it's called usury, USURY. It's illegal. And even if the contract says that, unless there's a severance clause in the contract, the entire contract will be void. So that is something that a lot of people don't are aware of. However, I was looking at one contract and it had a Delaware governing law clause, and in Delaware there's no cap. So the hack for me, and depending on how much interest you want to charge, is to have a governing law clause. And what a governing law clause. So Brandon and I, we're both in Florida. So generally most of the contracts I draft, we want so a governing law clause is different from a jurisdiction clause. A jurisdiction is where you can file a lawsuit. Governing law is what law applies to this contract. And it sounds crazy, but you can have a Delaware jurisdiction clause or a Florida jurisdiction clause, meaning that you can only file your lawsuit in Florida, but a Delaware governing law clause, which means the Florida courts are forced to use the Delaware law and interpret the Delaware law as it applies to this. But a lot of people don't understand this. Either there's no governing law clause, there's no jurisdiction clause, or they're just a mixed match. And these are they hills to die on? It really depends on the transaction. But this is something that a lot of people don't take into consideration. And they reach out to me, they want to file a lawsuit, and I tell them, we can do it, but unfortunately, I can't do it because it has to be done in Nevada or it has to be done here. And they didn't even realize this. And another thing I'll find is that sometimes when people use AI or they're using other templates from other third parties, there's a governing law clause that made sense based on that template. But ma'am or sir, you don't live in Ohio. So why does your contract have a governing law clause or a jurisdiction clause in Ohio? And then that's when they tell me, oh, I found the template online. So, and now you're stuck because usually they're trying to sue someone or send out a demand letter, and I can't even allege suing because in reality, they're not going to take the demand seriously because they know that we can't sue. So this is when you have these multi-state situations or when you're doing business with people, vendors or employees or kind of anyone, just look at your governing law clause to see if there is one, look at the jurisdiction clause to see if there is one, and make sure that it adequately reflects your business model and your personal preferences.
Love it. Love it. So the moral of this landmine component is our contracts are landmines. We need to understand them. We need to ensure that we have third party, non-preferential treatment, looking at it, seeing our risk, our opportunity, etc., tying it together, because the next thing you know, you're going to be in a circumstance where you're going to rely on a contract, whether you drafted it or someone else did. Maybe it doesn't have weight. Maybe it's got holes in it. Maybe you're on the hook for it. So these are the reasons why I always say you must have a lawyer on retainer. And one of the things that a lot of people don't understand is that when you have a lawyer on retainer, it's more cost effective. You're investing in a process versus just dollar to dollar time. And so one of the things I'd love, Vanessa, for you to share is how can everyone get a hold of you or get in touch or learn more about your practice?
Yeah, if you're interested about learning more about me and the practice, I would say LinkedIn is probably the best way to connect with us because we are pretty active on LinkedIn. You can follow the business page, which is Fedara Legal PLLC, or you can follow me personally, which is Vanessa Ferguson, and you can find me there. Outside of that, I would say the website. We also do have a YouTube. It's Vanessa Esquire, so you can find us there, and we make a lot of business related content there. And then yeah, you can also email me or just check out the website, which is fedaralegal.com.
And we'll have a bunch of this in the show notes as well. Thank you, Vanessa, for being part of this episode. I look forward to our next episode together. And thank you for tuning in to the Private Practice Survival Guide podcast. Don't forget to like us, subscribe, share us with your colleagues, because together we can thrive, not just survive. Thank you for tuning in to the Private Practice Survival Guide podcast. I'm incredibly grateful to each and every one of you. Exciting news. We're now available everywhere, from Spotify to Apple Podcasts to YouTube or anywhere you like to listen to your podcasts. So watch, listen, and reach out. If you love this episode, please drop a 5-star review. It truly means the world to me. Are you looking for more ways to elevate your practice? If so, now is your chance. Reach out, go to my website, or email me at brandon@wellnessworksmp.com. And remember, it's not just about surviving, it's about thriving.